Hello friends, welcome to Let's Crack UPSC CSE English. This is me, Dr. Sidharth Arora. And friends, we are continuing with our Laxmikanth series for polity. And for all those of you who are joining us right now, this channel is specially catering to the needs of those aspirant friends of ours for whom understanding the same subject that we are teaching right now in Hindi was difficult. So for those of you who are comfortable or who want to understand this in a bilingual manner, kindly go and refer to the same subject, the same topic on our other channel, that is Let's Crack UPSC CSE. For those of the aspirants amongst us who are interested in learning this only in English, Unacademy has brought this channel only for your requirement. Why? Because we don't want language to be a barrier in the process of learning. We want to help you out in all the ways possible. So the topics that we have done in the past, I'm sure that you have understood them in the form of a summary. I again want to bring it on record that for me, it is in my opinion, I think that Laxmikanth is one fabulous book for you to study, but you also should realize that it is not the only way of passing this exam, since that will take care of about 30 to 40% of your prelims exam. The rest of it you have to study. So if you think this is all and all that I have to study, sorry, this is not all and all that you have to study. There are multiple ways of studying. That is, you have to study from the Constitution, you have to study polity, current affairs, you have to read from the connection of the dots, because if you don't connect the dots, the examiner is not going to reward you. So we are going to help you out in trying to summarize Laxmikanth, right? But the rest of it, please be over and get it absolutely in the last part of your brain also, that this is not the final answer to your problems of civil service examination. We will, however, at Unacademy try and help you remedy this situation. How will we do it? Unacademy has brought for you several courses, and the announcement for the day today, and a huge announcement because many of our aspirant friends have put it in the comments on the YouTube, or they make me they send a WhatsApp message to me. So when are you starting the new course? And the new course has launched now. The comprehensive course on polity for UPSC CSE 2021 has been announced, and the same shall be launched on 11th of May. So 11th May, we are launching this course. This is a comprehensive course where I will make sure that from 11th May to 3rd of July, I will give you rock solid 24-karat preparation. This will give you a realistic chance of passing this exam. My friends, this is an altogether different ball game to pass this exam as compared to just appearing for this exam. If you want a realistic chance, this is your opportunity. What is very interesting here is Unacademy has drastically reduced the prices of their subscription. So those of my friends who are taking this exam in 2020 or for that matter 2021, make sure that you take a 12-month course which is available for 40,000 rupees. Use my code SID10. For those of you who were using SID Live, even that is applicable. You can use either of them, but you can use this code also, SID10, 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 or as I've already told you, SID Live, which I must have shared in the previous videos. Either ways, you can use all of these codes, okay, and you will get a 10% discount, and the same shall be available to you at 36,000 rupees. Those of my friends who are taking this exam in 2022 or 23 or for that matter 24, you are very lucky because you have 2 or more than 2 years to prepare for this exam. Again, use my code SID10, take a 24-month course which is available to you at 48,000 rupees. You will get this course for 43,200. Crunch some numbers, do some maths here. If you are a 1 year, if you take this course for 1 year, you're taking it for 36,000. And if you're taking this course for 2 years, it's just merely 7,200 rupees more. For 43,200, you'll get this course. Use my code SID10, take a wise decision, and you will be prepared for giving you a realistic chance of passing this exam. So join now, don't waste this opportunity. And now for today's topic. So today's topic starts with one of the most interesting discussions on polity, and most of the students are very happy reading about it. Although I'm afraid that I must say this, that most of the students just read it very superficially. They don't really understand the essence of it. So to understand the essence of it, it is amongst the most important essence of polity, not only for civil service examination, but for lawyers also, for any student of law. It is very important for you to understand and comprehend what are rights. See, please pay attention, sit back, relax, and enjoy this part. Most of these things which I'm now saying is probably not even written in Laxmikanth, but I can't stop. myself from discussing all these parts. So when the concept of rights started, so okay, the word rights or the concept of rights is very, it's not very old, it's not too far back in human history that you can trace the origins of the words rights. In fact, for the longest period there was nothing called as rights, there was only delegation. So there was a concept called as rex lex. What was that? That it was king had all the powers. This was all doctrine of divinity, in the sense that he was the representative of God from up there. Okay, so up there was God and here was the king. Now the king's subjects and the kings himself, okay, they misuse these powers, and this led to a revolt or a rebellion, which ultimately ended in what is called as the Treaty of Magna Carta. The full name is called as Magna Carta Libertatum. This happened on 15th June 1215 AD, and at a place in a field, okay, if you read about it, it's a field, okay, at Runnymede, okay, Windsor, that is in England. These King John of England, they signed a agreement, please understand, and that agreement began what was called as the concept of rights. This agreement was called as Magna Carta. So Magna Carta or Magna Carta Libertatum was the origin of rights for the first time. Very basic rights, but rights started nonetheless. Gradually these rights increased in number, then these rights increased in scope and geography and so on and so forth, and then came the United States of America. 1776, 4 July 1776, we had a huge country formed, which is called as the United States of America. Now when America was formed, they also wrote their constitution. It was the first written constitution also. But at that time it was criticized. It was criticized in the words that although there were rights, there was a constitution, it told what the government can do. It did not tell what the government cannot do. In other words, it was not placing a limit on the powers of the state. This concept was brought in by the introduction of Bill of Rights. And this Bill of Rights, the first 10 amendments, I am repeating this part, the first 10 amendments of the Bill of Rights gave rise to what are called as fundamental rights. Now, what are fundamental rights? Fundamental rights will ensure human existence. What is that? It is ensuring human existence. Far later in life, okay, if you fast forward life, then you come to Francis Currale case and the Maneka Gandhi case. See, many of these things may not make sense to you, but I'm going to tell you still nonetheless, right, because it is a summary part that I have to finish with all of you. However, it is your duty and you should make sure that if possible, if you're not able to study from yourself, then please join us on our courses. But these are some things that you have to draw connections with. So in the Francis Currale case and the Maneka Gandhi case, far later, our Supreme Court also realized that Article 21, that is one of our fundamental rights, does not speak only about rights. It talks about life is living with choice and dignity. Hence, it is ensuring human existence. Then it is fundamental to what? Fundamental to why? Because of the concept here that it is the fundamental law of the land. What is that? It is fundamental law of the land. The very basic law of the land is the constitution of that country. So the same constitution is giving it guarantee. Hence, these rights are called as fundamental rights. These are justiciable. What does that mean? That the courts, right, for example, in our case, the Supreme Court or the High Court has the powers to enforce it. So you can enforce these rights through the courts, hence called as justiciable. When Dr. Ambedkar had the opportunity to write fundamental rights for us, okay, he did not even wait for any amendments. He gave us it in the original constitution itself as part 3 of the constitution, that is from Article 12 to Article 35 of the constitution. So Article 12 to Article 35 of the constitution deals with part 3 of the constitution, and these are what are called as fundamental rights. 12 and 13 are giving you definition, so we'll get to them later. Article 14 to 18 deal with what is called as rights to equality. Rights to freedom are Article 19. Rights against exploitation, rights of freedoms are also sometimes subdivided into rights of protection also. That is Article 20, 21 and 22. So these are with protection. Rights against exploitation are 23 and 24. Rights of religious freedom are 25, 26, 27 and 28. Cultural and educational rights are 29 and 30. Property is 31 and constitutional remedies is 32. Now that leaves us two big parts, 1, 12 and 13, which are giving you definitions. 12 gives you the definition of the word law and 13 gives you the definition or rather description of the words judicial review, and they describe the power of judicial review for Supreme Court and the High Courts. Then you have on the last part of part 3, that is 33, 34 and 35. We will look into these summaries also, but at a later stage. 33, 34 and 35 are exceptions to the rules of fundamental rights. So these are exceptions and they do not actually fall under the same method of studying as from 14 to 32. So we will look at first Article 12, that is state. Now state is a very important part. Now please pay attention. The entire concept of fundamental, why is fundamental rights so important? Fundamental rights is so important because a citizen or an individual is very weak as compared to the decision making power of the state. So state, I hope you understand, will be combining executive, legislative and judiciary. The executive, legislative and judiciary is very powerful, very powerful. In contrast to the state, an individual is very weak. Now, who will protect this individual from the state? The individual will be protected by the concept of fundamental rights. Wow, awesome. So, state is a very important part. Fundamental rights state has very important powers, but the individual also can be protected by the arbitrary use of power by the state by use of fundamental rights. So first I have to know what is a state all about. States means, according to Article 12, it means the government of India, it means the Parliament of India, it means the government of the states, it means the legislature of the states and any other local authority. I am repeating this part, any other local authority within India or under the control of government of India or under the control of government of India. So everything, so Parliament is state, yes. Police is state, yes. CBI is state, yes. Army is state, yes. Chief Minister is state, yes. Prime Minister is state, yes. Judiciary is state, in a way, yes. Okay, although we'll get into this at a later stage. The judiciary is not strictly considered to be part of Article 12, but still for the time being you can understand that state is very, very powerful. So Article 12 defines the word state. Article 13 defines or rather describes what is law. It says that if you make any law, any legislation, any amendment, any order, any action which is inconsistent or in derogation with part 3 of the Constitution, then it cannot be law. Now, if you make such a law, then what will the Supreme Court do? Then the Supreme Court or the High Court will strike it down. That is, it will declare it as null and void. So, Article 13 is describing the power of judicial review. That anything which is inconsistent with the Constitution will not be accepted by the Supreme Court or the High Court and it will be declared as null and void. This is described as the power of judicial review. So why did you put so emphasis on that word judicial review? Because it is not written. The word judicial review is not written in Article 13. It is described. These are very dangerous questions and most people are not aware of these things part. So now we will first look at rights of equality. First is Article 14. It talks about two concepts. One is equality before law and the other one is equal protection of laws. So we'll just have a quick division on this part. Equality before law is a negative concept. Equal protection of laws is a positive concept. Equality before law is an English law concept and the equal protection of laws is an American law concept. Now, why would I say such thing? See, when I say about equality before law, this is something that we have heard of for the longest time. Like how? That there shall be no discrimination in the eyes of law based on status or position. I agree. This is called as equality before law. No discrimination. Because there is no discrimination, I call it as a negative concept. Don't do discrimination. What is equal protection of laws? It says a very different thing. It is a positive concept. It's a reasonable discrimination is allowed. It says like should be treated like. In other words, equals must be treated equals. Unlike should not be treated as like. As an unequal should not be treated as equals. This allows us to do what is called as reasonable discrimination or reasonable classification. So this is very important. Why? Because that will allow us to make special laws for women, special laws for children, special laws for juveniles, special laws for scheduled caste, scheduled tribes. Why? Because everyone cannot be treated equally arithmetically. Anybody who requires a special care, special provision can be given. This is our beautiful concept of the equal protection of laws. So American law says only about equal protection of laws. English law says only about equality before law. Article 14 in India will speak about both of them. So the word here is Article 14 says that the state shall not deny to any person, not citizen, person. The state shall not deny to any person equality before law or equal protection of laws within the territory of India. So this is a very important word that you have to pay attention. So this is the exact text of this. This is what is ensuring what is called as rule of law. So there was a concept called as rule of law which was given by A.V. Dicey. It can be maintained only by Article 14. Next is Article 15. It says no discrimination on certain grounds. Please understand, discrimination is the law of the nature and it is also the law of a country also. You cannot say no discrimination and full stop. Sorry. We will discriminate. Okay. Every different treatment is not considered as discrimination, first of all. So merit-based discrimination has to be done. Otherwise, all of us will become IAS officers. Not possible. So those of you who are more intelligent, more hardworking should become IAS officers. The other ones should not. But when Dr. Ambedkar was writing Article 15, he gave a certain example. So Article 15(1) says, there shall be no discrimination on the basis of race, religion, caste, sex or place of birth or any of them. This is a very important part, that you should not be discriminated on race, religion, caste, sex only or place of birth. This or place of birth only or any of them, or there shall be no liability, no restriction, no disability because of this. This was Article 15 subclause 2. But Article 15 is also very important, that Article 15 is a general bar on discrimination. So examples were given, for example, with regards to use of water for bathing ghats, okay, use of public places, use of hospitals, use of public methods of transport and so on and so forth, or the places of worship. So Article 15 was a general discrimination or general bar on discrimination. Very awesome thing about Article 15 is that it speaks volumes about Dr. Ambedkar's large-heartedness or the founding fathers' large-heartedness. Imagine by writing Article 15 and later on Article 15 subclause 3, which says that there shall be special provisions for women and children. Don't you realize that the founding fathers are actually acknowledging that deep down on the ground, okay, there is discrimination which we will have to look into. So there is discrimination and we will have to look into that discrimination. Otherwise, the entire situation could have been very theoretical. The entire exercise of constitution writing could be very, very theoretical. So Article 15 speaks about this. Now later on, by the first constitutional amendment, Article 15 subclause 4 and 16 subclause 4, we are also providing reservation. Why are we doing it? Because as I said, discrimination, every different treatment cannot be understood as discrimination. We can go into a long discussion on this part, but that is only possible. That's not possible on a YouTube video. That India does not believe in equality. Primarily, we believe in equity. That is, whoever needs more, the state will give him more. Next is Article 16. It talks about equal opportunity in public employment. Now, the same thing, but with regards to public employment, government job. So it says the state shall give equal opportunity for public employment and there shall be no discrimination on the basis of race, religion, caste, sex, descent, residence or place of birth. In other words, there were more grounds were added. So Article 16 also talks about what is called as level playing field. In the words of Dr. Ambedkar himself, not everyone is equal. Okay, there have been many people, many at that time scheduled castes and scheduled tribes and later on the other backward classes also, who have been left far behind in the process of development and we must cater to them. So my reservation policy is primarily aimed at providing what is called as level playing field. Article 17 talks about abolition of untouchability. Now this was huge. So I hope you are aware of this. Mahatma Gandhi spent his entire lifetime fighting for Harijans, okay, for the equality on against this shameful practice of untouchability. Dr. Ambedkar himself was a victim of untouchability and the other bad practices related to that. So Article 17 says we shall abolish untouchability in all its forms, zero exception, no exception at all, and we shall ensure that in case anybody practices untouchability, it shall become a punishable offense. So we passed what is called as Protection of Civil Rights Act of 1955, in which we made it a punishable offense. Later on, we realized that it is not enough, and that is why we passed what is called as the SC/ST Prevention of Atrocities Act of 1989, which makes it even more stringent part. Very important for you to remember, Article 17 has zero exception. Whether by action, whether by words, whether by gestures, whether by writing, commenting, anything, untouchability cannot be practiced. Another, in the last part on the freedoms or on the rights of equality, is Article 18. Now this is only dealing with those titles. So this is abolition of titles. So Britishers were using titles, state-sponsored titles, for political appeasement. Raja Sahab, Diwan Sahab, Banda Bahadur, Sahib Bahadur. What were these? These were methods of political appeasement. But what happens because of this? You become unequal. Not because you are at a disadvantage, but because you are at an advantage. So Article 18 abolishes any of these titles which have been given by the state. So it says the state shall not confer upon any state except military and academic titles. So military titles, yes, captain, major, colonel, general, all of these are absolutely acceptable titles. Why? Because you've earned it by merit. Academic titles, doctor, advocate, chartered accountant, engineer, this you've earned it. These titles are not abolished. The titles which are conferred by the state, which are primarily dynastic titles, which go from one generation to another without doing anything about merit, these titles have been abolished. What is funny about it and what is interesting about it is that there is no punishment, so to say, in case the state gives such a title. All they are asked to do is to withdraw it. So in a way, yes, it is abolished, but unlike Article 17, which makes it a punishable offense, Article 18 does not provide any punishment for that. Also remember, Article 18 subclause 2 says that any citizen of India cannot even accept a title from a foreign state. In other words, Article 18 subclause 2 is applicable to citizens. Till now, 14, 15, 16, 17 is available or is applicable to both citizens as well as non-citizens. These are some fine questions they can ask you from middle. This is proper material. People miss it out. But even though I'm doing summary, but I cannot restrain myself. I cannot stop myself from sharing these things also. These are very important for all of you. So summary here is, these are guaranteed rights, fundamental rights. These are crucial for human dignity and these are justiciable. So the courts can enforce them. Both the Supreme Court and the High Court can enforce them. This is very important. So my friends, in this limited period of time, I can just summarize for this part. I hope you understand that there is far more to it than what I have just discussed. Okay. But for summary purpose, this is fine. I welcome you to join my comprehensive course for polity for UPSC CSE 2021. And I'll be happy to deal with these topics in far more detail. If you want to join, please join. Either use the code SIDLIVE10 or use the code SIDLIVE. And in the words of Unacademy, my friends, let's crack it. Until next time, God bless and thank you.